Hi everyone. Thanks for joining SCL Talk series by SCL Turkey. Today we will talk about another interesting subject for construction contracts. Liquidated damages. Our guest is Mark Grasso from Queen Emmanuel Law Firm in London. Mark is a partner in Queen Emmanuel. Hi Mark, thank you very much for joining us today.
Thanks, Ekram. It's a pleasure to be able to be with you today and to do this in person and also to have the connection with my colleagues in Turkey in this remote manner. So thanks again.
Thank you very much. Mark, LD is a very interesting subject in construction contracts. It is contentious as well. My first question is related to LD concept under English law. English law is known for respecting freedom of contract. What are the grounds on which the contractors can challenge liquidated damages under English law?
Yeah, thanks, Ekram. You're right that English law respects freedom of contract, but there are some limits to the contractual terms which English courts will enforce. Historically, the civil courts in England have seen their job as being to compensate a party which may have suffered from a breach of contract, but not to penalise. Penalties they see as the role of criminal courts. So under English law, historically there was, or the approach taken by the courts was that if there was a penalty clause, that is a clause which creates a secondary obligation when the primary obligation is breached, the courts would examine whether the penalty was a penalty, and if it was, then they would deem that it was unenforceable. But if the penalty aspect or the fixed sum aspect of the penalty clause was a genuine pre-estimate of the loss that the employer, say in the construction context, would suffer as a result of the breach, in those situations that the court would uphold the payment of the fixed sum. So if in entering into a contract the parties had agreed that or decided that a sum of, let's say, £10,000 per day of delay for construction of a hospital was a genuine, not necessarily accurate, but a genuine pre-estimate of the loss that the owner would suffer, then that was okay. Things have moved on a little bit since then, and I think it's fair to say that courts in England take a pragmatic view of liquidated damages clauses today, in that they recognise that they are part of the risk and reward allocation that parties agree upon when they sign a commercial contract. There are still some limits, but they really arise in extreme circumstances. And to answer the question as to what contractors can do, they really need to demonstrate that the penalty aspect or the fixed sum aspect of a liquidated damages clause is truly excessive to the actual loss which the employer, again in a construction contract context, will suffer. That can be quite challenging because English courts also recognise that sometimes it's not just a comparison between actual loss versus the liquidated damages sum, because in, for example, the public sector context, a public sector body, say a government building a hospital, might have a legitimate interest in the hospital being built on time because it wants its citizens to be able to get good medical care. That's not a financial interest. The government may not suffer any financial loss if the hospital is delivered late, but because of the legitimate interest, the courts may still uphold the liquidated damages sum. So, as I said, challenging for contractors. There really needs to be a forensic analysis comparing the actual loss to that the employer has suffered to the liquidated damages amount in the contract.
Thank you very much, Mark. The point about the penalty and the penalty clauses are also interesting to me. Most civil law systems, to my knowledge, recognize penalty clauses. What is the position under English law?
Under English law, it's not quite the same as civil law systems. Under English law, classification of contractual terms doesn't really arise. Having said that, the legal principles which I've just mentioned do come into play when there is a penalty clause in the way that that term is generally understood. That is a secondary obligation which comes into effect when the primary obligation is breached. So putting it in construction terms, the primary obligation is contractor must deliver project by milestone date X. The secondary obligation is if contractor doesn't deliver on time in breach of the primary obligation, then contractor must pay damages at the rate of Y. That's what a penalty clause means. And the legal principles that I've just mentioned under English law, being able to challenge the penalty aspect of that or the liquidated sum that's payable under such a clause, those principles of English law only apply in that context. And I think that's worth emphasising, because what one can do under English law is structure a contract in a different way so that you can achieve a similar effect, but not by using a penalty clause. And this is done a lot in oil and gas contracts. You might have a take or pay arrangement where the customer is agreeing effectively to pay a sum every month, irrespective of how much gas, say, it takes. That could be seen as being, in effect, a liquidated damages clause, but it's structured as a minimum purchase obligation, so it avoids any challenge on the basis that it's an impermissible penalty clause. In the construction context, structuring a construction contract as a concession contract also gets around the issues concerning penalty clauses under English law. So you can achieve something very similar if it's a concession contract, simply by saying that the payment for that the employer makes for the concession only starts on project delivery. That in effect is another way of achieving liquidated damages and avoiding any sort of risk of the contractor challenging the clause on the basis that it's an impermissible penalty clause.
I see. How about Turkish law? Knowing that the penalty clauses are enforceable under Turkish law, how the liquidated damages clauses can be dealt with by the contractors under Turkish law?
Yeah, so as you've mentioned, first of all, Turkish law recognises freedom of contract and as part of that recognises penalty clauses. Article 182 of the Code of Obligations says that parties can freely determine the amount of the penalty. So starting point is they're valid. There are various limitations, however. If the primary obligation is illegal or becomes impossible to enforce, then the penalty falls away and can't be enforced. That perhaps has some application in the current COVID context. But I think probably of more general application to contractors is the last bit of Article 182, which says that the court should lower the penalty if it is excessive. Now that's an interesting provision, and it differs slightly from the equivalent provisions in other civil law jurisdictions. First of all, it's a mandatory obligation on the court in the way it's expressed. The court or the judge must reduce the penalty if the penalty is excessive. In other jurisdictions there's a discretion on the court, but in Turkey it's a mandatory obligation on the court to do so. And also the criteria by which the court assesses the penalty and moderates it. That seems, on the terms of Article 182, to very much be at the court's discretion to determine what is excessive, and having done so, to determine how the penalty should be moderated. And I think also in terms of the factors that the court in Turkey can consider in determining whether a penalty is excessive is not just the actual loss versus penalty amount comparison, but also the economic positions of the parties. And there may be scope for contractors to challenge a penalty clause under Turkish law, not just on the basis that it's excessive in terms of the comparison that I've mentioned, but also that it's excessive because it's would amount to too much of a burden on the contractor's financial
Yeah,
position.
our time is really limited. One last question I'm going to ask is about the jurisdiction in Saudi Arabia, because it is a market that Turkish contractors are working intensively. What is the liquidated damages position under the law of Saudi Arabia?
Sure. Interesting question, because Saudi Arabia is a very interesting jurisdiction, quite a unique jurisdiction, because it doesn't have a civil code. Rather, the law of Saudi Arabia is the Sharia. And there is no system of precedent in terms of case law. Rather, each case is decided by the judge on their understanding of the Sharia or the Quran and the writings of scholars and so on. So outcomes can be a little bit unpredictable. Having said that, the Sharia recognises freedom of contract. The Sharia does not contain any equivalent to Article 182 of the Code of Obligations in Turkey, so there's no express recognition of penalty clauses or the ability of parties to agree a penalty. And thirdly, under Saudi law, only direct financial loss is compensable for breach of contract. Now, applying those three principles to a liquidated damages clause is not easy, because the principles potentially conflict with one another, but the way that things tend to work in practice in that jurisdiction is that a court in Saudi Arabia will expect the party claiming liquidated damages to establish that it has suffered some loss. So it's not just enough to point to the liquidated damages clause and then shift all of the burden to the other side. The employer needs to show that it has suffered some loss, but then recognising freedom of contract, and parties have agreed to this clause. Again, what tends to happen in practice is the burden shifts to the contractor to show that the amount claimed is excessive. So the ultimate position there is something in between, perhaps common law and civil law. But one thing I should just note in closing is that under the Saudi procurement law, in public contracts entered into under that law, the public body is entitled to deduct a penalty for delayed completion. That doesn't apply to every government contract, though. It does need to be a contract that is specifically entered into under the procurement law.
Thank you very much, Mark. It was really enlightening. I enjoyed listening your answer to my questions, and we are looking forward to listening you in other SCL events.
Thanks very much, Ekram. Very nice to speak to you today.
Thank you very much.
Thank you.
See you in another SCL Talk episode. Bye for now.
Bye.